All right, sir, you are Elazar Stansberry, and Mr. Stansberry has been charged with the offense of murder. The case has been filed and not indicted yet. Mr. Burbank was appointed to represent Mr. Stansberry. Ms. Holmes has joined in just with regard to filing an application for writ of habeas corpus seeking a bail reduction. And so we set it for this hearing. Mr. Stansberry's bond is currently set at $1.5 million. And Ms. Holmes, you may proceed.
Thank you, Your Honor. Your Honor, I guess in regards to the case, we have limited information. All we have at this point is a PC affidavit, which is kind of generalized. I have met with Mr. Stansberry in regards to the allegation, and we do believe once we provide a packet, possibly once this case reaches the district attorney's office for the grand jury to review, then there may or may not be an indictment. We don't know at this point. Mr. Stansberry has been in custody since November 7th. I did meet with the intake division on yesterday. They do not have the case received at the district attorney's office at this point. It is still with the police department. And so we do not have a timeline on when this case may possibly come to the district attorney's office. Your Honor, Mr. Stansberry, with the current bond amount, we do believe that it is excessive in looking at the other individuals who are currently incarcerated. Mr. Stansberry has the highest bond at the jail, him and one other inmate. And looking at other individuals at the jail, especially those who have murder charges that are not indicted at this point, their bonds currently range from $250,000 to $350,000, and I do have those names if the court needs those. Your Honor, we are asking that in light of this, that Mr. Stansberry bond be reduced to a reasonable amount. He does have family here who will make sure that they secure his presence. Just briefly, although we don't have all the information, I can say from what I do know that in regards to this particular case, Mr. Stansberry did not flee. He's actually the one who called 911 after this had occurred. He was cooperative with law enforcement and providing his statement of events and everything that happened. So I do believe that that is a mitigating factor for the court to put into consideration, that we do not believe that he will be a flight risk if the court reduces his bond to a reasonable amount to allow him to bond out. Since this has occurred, Mr. Stansberry has lived in the area since 2020, in which he was relocated from a hurricane, in which he moved with, at the time, with his children, who do reside here in Beaumont with their mother, in which they share joint custody. Since this has occurred, Mr. Stansberry has lost that apartment where this occurred at his apartment. If he is allowed to bond out, he does plan, or is in hopes of planning, to live with his current girlfriend, who's here as well with his parents. She lives at 25419 Richton Falls Drive in Richmond, Texas. And that is where he hopes that he will be able to reside if allowed to be released out on bond. Both of his parents are here. They're residents of Louisiana. His father resides in Lake Charles. His mother resides in New Iberia. But Mr. Stansberry does hope to be allowed to stay at the home in Richmond, Texas, since he doesn't have any ties to Beaumont except for his children at this point.
What's girlfriend's name?
Jazzy Starks.
Does Ms. Starks have any criminal history?
No, she does not.
Okay. All right, anything else?
And Mr. Stansberry also, he does not have any felony conviction history as well, Your Honor.
Okay. All right, thank you. Ms. Malfino?
Judge, I had the opportunity this morning to speak briefly with Detective Jackson. Obviously, he is not here this morning. If the court would like to hear from him, I would ask your consideration, because we have one more docket. If you would like to hear from him in person, if we could maybe hold on this until next week before any substantial reduction if this bond were to be made. I went with Ms. Holmes and we both visited with intake yesterday. We're both aware of the situation that the case has not been brought in, although a warrant was walked through based on the facts they had at the time of the offense. I have brought that to the attention of the detective, not knowing if the case will actually fall in this court next door to whom it will be assigned. I have very limited amount of information, but I did make it very clear to Beaumont Police Department, and they were very receptive to the fact that this case, even if it is absent some of the documentation, such as the phone download that the detective mentioned, it needs to be brought sooner rather than later to the district attorney's office, in all fairness to the defendant. But as the court has very limited information about the facts, I think there is going to be a dispute with respect to an affirmative defense versus an intentional and knowing murder. I don't disagree with that. I think the sides are not in the same position right now, but it's kind of hard to read between the lines with a 3-sentence probable cause affidavit. I think based on what this court has done recently and based on, Judge, just on the fact that every single weekend we turn on the TV and there's a murder in Jefferson County, I think that bonds in this county to protect this community, understanding of the defendant's rights, need to be substantially more than they have been in the past. And I think the court is beginning to follow, at least this court, is that trend. I'm not saying that an amount of relief is necessarily opposed by the state, but I don't believe, just based on what I know, Judge, and based on everything we're dealing with in this community, that something as low as $200,000 would be sufficient at this point.
My biggest concern at this point is the fact that this is from November 7th and you guys don't have it yet. And I think obviously the nature of the offense is we're tired of hearing about these offenses. It's the worst offense we can have. However, I mean, everybody has the right of being presumed innocent, you know, and we've got somebody sitting here for 30 days without a case even in your office, much less indicted yet. And I think that's a big problem that needs to be addressed. And it doesn't leave me a lot of, I think legally, probably required to do relief, because obviously the state couldn't be ready because you don't even have the case yet. And so that puts you guys in a bad position as well. Ms. Malfino, I think the facts are somewhat important, and I wouldn't mind hearing from Officer Jackson, however, or Detective Jackson. I just don't think that at this point, based on the time frame, that I can not give relief. Obviously, I think that the lack of criminal history is important. So that goes into this, because if we've got any type of criminal history, we'd be looking at something a whole lot different. I don't disagree with Ms. Malfino about what's going on in Jefferson County, but I also have to individualize each case. So that being said, I'm going to grant the relief. I am going to reduce the bond in this case to I'm going to reduce the bond in this case to $500,000. Condition of that bond, if made, or conditions of that bond, if made, are that Mr. Stansberry will be ordered to live in Richmond, Texas, at 25419 Richton Falls Drive with Ms. Starks. Will be required to wear a GPS monitoring device and be on house arrest, other than for coming to court and for visiting with your attorney. Without my permission, you don't go anywhere else if you make that bond. If you've got doctors, if you've got different things like that, you get with Ms. Holmes, she gets with me, or Mr. Burbank, either one. They get with me, and then I either give you permission for that or not. Other than that, you're on house arrest with the GPS monitoring device. We'll know immediately if you leave the house without permission. The bond will likely be what it is now, if not more, if that happens. Are there any specific, I guess I don't really need to worry too much with a no contact because I'm going to have him on house arrest if he makes the bond. But obviously you're not allowed to be anywhere near that old address or anywhere near anyone who was involved that night. You're not to have any communication with anyone involved. So that all doesn't just mean contact in person. It means you can't talk to them, send message to them, anything at all. Do you understand? All right.
Judge, I'm sorry, go ahead.
I'm just one, will his children be allowed to, I guess, come visit him? His children do reside with their mom here, well, they
Yeah.
joint custody, but
That's fine.
they can visit him.
Yeah, I mean, there's no allegation that there was any issue with regard to the children or that I can tell from the little bit of information I have. So whatever that, if they have custody, I don't have any problem with that. What were you?
Judge, I just wanted to ask the court to consider, for what it's worth, the order that he not possess a firearm or be in a home with any firearm. And also,
Yes.
I don't know how to request that you order this, but I would prefer, and I think it would be beneficial to the court and to the fact that this is a Jefferson County jurisdictional issue, if he obtains that GPS before he leaves here, so that
They'll put it on before he won't be able to leave jail without it.
somebody we work with, such as Johnny's, would be able to keep the
No.
court informed of his whereabouts.
It has to be, when we order a GPS, it's part of them getting out of jail. They don't get out of jail until they come put it on their leg there, I'm pretty sure. And so, isn't that how it works on GPS? I know not on drug patches, but GPS, they go put them on.
Before they get out.
Yeah, okay. So that gets taken care of through the bondsman, and they get somebody to get that done upon leaving or checking out or whatever happens there. Okay? So you are ordered not to be in possession of any firearm. If there are firearms in the home of Ms. Starks, they all need to be removed. So if you're going to live there, then you're technically in possession of that place. You can't have any firearms there. Make sense? Okay. We will... If there's any issue and the case is not received and indicted soon, obviously this is something that would have to be revisited as well.
Yes, ma'am.
Okay, thank you. You can go back with the bailiff.
So, Judge, on Mr.
All right, so hold on. You're Dalvius Williams, and this is 25 DCCR 0176. Mr. Williams is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
Your Honor, Mr. Williams, and I filed the motion in this case after I explained and sent Mr. Williams a communication explaining what he was subject to in terms of punishment and what the state has indicated their enhanced punishment range and a motion to accumulate coming on a jury trial. He immediately told me he did not want me to represent him because I don't show his best interest. He would like to fire me, so.
You're court appointed, right?
Yes, Your Honor.
You don't get to fire your court appointed lawyer. You can fire someone you hire. Mr. Wilkerson is an excellent attorney. He handles many cases for all of us here in Jefferson County. If he's advising you of whatever your situation is, then your situation is what it is. So we can go through and what you're charged with and make sure we're all on the same. I feel like we've done that before because we've already had a plea bargain rejection, but let's do it again. It looks like you're charged, it's a third-degree felony, which means the punishment range is between 2 years and up to 10 years. However, it looks like, has there been, I don't see a notice filed of extraneous, but are there some that you
Yes.
anticipate filing?
Yes, Your Honor.
Mr. Smith?
Yes, Judge.
2 prior stages.
There's a third degree, excuse me, Judge.
Hold on just a second while they get this figured out, and then I'll let you ask any questions you have, okay?
No, that was me.
So Judge, there's a state jail for criminal negligent homicide. There's another state jail for attempting to take a weapon. And then there's the third degree that Mr. Smith mentioned. There are no other TDCJ convictions.
So the third degree felony conviction, if true, would enhance your punishment in this case, if you were found guilty, to the second degree range of punishment, which is between 2 years and up to 20 years. Do you understand that? Okay. And it looks like we previously did a plea bargain rejection, and at that time, the third degree felony was checked off instead of the second degree admonishment. But I do want to make sure you understand today that if you go to trial, and if that conviction for the third degree felony, the state jails don't enhance you, but the third degree would, to a second degree felony range of punishment. It looks like that rejection was for a 4-year term in prison. Is that still the offer?
That was the offer as of this morning.
Okay, so the offer is for 4 years in prison. You already said that you didn't want that. If you want to change your mind after discussing your options with Mr. Wilkerson, then we can take care of that. If you don't, then we'll set your case for trial. Mr. Wilkerson will prepare for trial, and we'll get it taken care of as quickly as possible. Yes, sir.
There was one more thing. The state had indicated an intent to file a motion to accumulate. He just had an 8-year sentence on an MTRP.
If you recall, Judge, we had a motion, a contested motion to revoke probation with this as the allegation. We proved that up. You gave him an 8-year sentence.
Okay.
So that 4-year sentence that we had offered today was to run concurrently with that.
Okay.
If he rejects that, then we will file a motion to stack whatever he receives from the jury in this case on that 8 years that he's already served.
So I want you to understand, so the third degree conviction, is that something other than the conviction? The revocation, or that's the one that,
The revocation was for a injury to it. So that was,
the prior conviction that y'all are talking about, that third degree,
That's on the MTRP.
that's on the MTRP?
Yes.
And so, does everyone agree that timing, though, the conviction of that,
I see what you're saying. I don't think that one does, but I think the 2 state jail felonies bump it up to a 2.
they don't do anything? State jails don't do anything to a TDC case. And if I convicted him on an MTRP after this offense date, then he wasn't convicted on the offense date, and so that doesn't make it sequential. Am I right?
I think you are right, Judge. So I do think it goes to the...
I don't disagree that there could potentially be a cumulative request, but I don't think it would enhance his punishment, because I think it has to be a prior felony conviction before the date of this offense. Help me out, am I right? I'm looking at all the lawyers, everybody.
I think
Yeah.
you are, Judge. Yeah.
Okay, so forget everything we just said. The range of punishments between 2 years and up to 10 years in your case. The state's offered 4. You can take your 4, you can go to trial. Mr. Wilkerson will remain your attorney. So what do you,
I want to go to trial.
Okay.
And I want to see what is the outcome if I can get my own lawyer.
well, yeah, so you have the right to hire your own lawyer at any time. But because you're in custody, we're gonna move forward with your case. I'm clearly gonna appoint you someone. You're not just gonna sit in jail without a lawyer. We're gonna make sure you have representation, and your case is gonna move along. So if your family or you has the funds to go hire someone, then by all means, you need to get them hired, and they can substitute in, and they need to get ready for trial also. Until or if that happens, if it doesn't, we're going forward, case will be on the trial docket, we're gonna move forward. We're not gonna keep putting it off for that to happen. If it happens, great, but as of right now, you're rejecting the 4. I also wanna make sure you understand, Mr. Smith, is there any reason to believe that that offer of 4 would change?
no, Judge, and in fact, we had offered to dismiss the case against the co-defendant in this case for his plea in this case to run concurrently at the time he's already serving. In fact, it would be for less time, so.
Okay, so I do want to make sure you understand that there's not going to be any new offers. It's the offer remains what it is, no matter who your lawyer is.
Yes, ma'am.
And that there is the potential for anything you get from a jury to be stacked on top of that 8 years that you already got. You understand that too? Okay, we'll get it set for trial. You can go back with the bailiff. Not today. Good morning, sir. Are you Derwin Cooley? And Mr. Cooley, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. And so, Mr. Macon, will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Cooley, we're going to go through this motion to revoke your community supervision and get pleas of true or not true to those allegations. In cause number F16-26460, I have a motion to revoke your community supervision. Looks like you were placed on probation January 3rd of 2023 for obstruction or retaliation, a third-degree felony, and that was a 10-year sentence that was probated for 10 years. Is that correct?
Yes.
Okay. I'm going to print this out. I'm just having a hard time reading on the screen. It looks like count 1 alleges that you violated your probation by committing the new offense of tampering or fabricating physical evidence with intent to impair, August 9th of 2025. And is that true or not true?
That's untrue, Your Honor.
Mr. Cooley, I just need Mr. Cooley to plead true or not true to the allegations.
Okay, they have Jefferson County on the motion,
Okay,
and I believe this is referring to an arrest in Dallas County.
okay. We can,
Okay, that's-
His Dallas.
all right, does the state, do you want
We
to,
move to amend that to Dallas.
any objection to
There's no
that
objection, Your
amendment?
Honor.
Okay, so then, Mr. Cooley, so the allegation in count 1 is that you committed that offense of tampering or fabricating with physical evidence with intent to impair August 9th of 2025 in Dallas County, Texas. And is that true or not true? Count 2 alleges that you failed to report to the probation office as directed by mail for all of 2024, January, February, March, April, May, June, July, and August of 2025. And is that true or not true? Speak up. Count 3 alleges that you failed to immediately report to the probation officer your change of address. Is that true or not true? Count 4 alleges that you failed to immediately report to your probation officer that arrest for tampering or fabricating physical evidence with intent to impair. And does the state wish to amend that?
Yes, we did get it to Dallas County. So.
Any objection to making that Dallas County? All right, so the allegation is that you didn't report the arrest from Dallas County to your probation officer. Is that true or not true? Count 5 alleges that you possessed a drug, methamphetamine, August 9th, 2025. Should that be in Jefferson County or Dallas County?
Dallas. I believe that's going to be Dallas County as well.
Any objection to making that?
No.
So the allegation in count 5 is, again, that you possessed methamphetamine in Dallas County, Texas, August 9th of 2025. And is that true or not true? Count 6 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? I'm sorry? Count 7 alleges that you were at a location other than at your residence at approximately 12:12 a.m., August 9th of 2025. And is that true or not true? Count 8 alleges that you failed to pay your court-assessed fees as directed as of August 26, 2025. You were $268 behind. Is that true or not true? Okay. Did you enter your pleas of true to counts 2 and 7 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find counts 2 and 7 true, find sufficient evidence to revoke your probation. However, I'm going to reset your case for a sentencing hearing where the state can bring any evidence with regard to any prior, those offenses if you wish to. I need to know if you intend, I guess, on having officers, how long you expect that to take. And then we'll get it set for a hearing. I'll get an updated pre-sentence report, and we will go forward from there. All right? You can go back with the bailiff. We need a print. If you'll step in front of the clerk real quick, she needs to take her thumbprint, please. And figure out whatever to do on that state jail later. All right, sir, you're John Jones? Give me just a second. Let me get your everything pulled up here. See, Mr. Jones, in cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with the state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years. In clause number 25, DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet, in those cases, some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer, if you wanted to enter pleas of guilty, for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case, with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, Your Honor.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right, is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them would come out of one occurrence, and then there's one from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes.
All right, and do you want to have all of your cases set for trial?
Yes, ma'am. I got a question though.
Yes, sir.
It's my offer 35, right? Like that's what the DA's offering, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year off.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would, listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants, all right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will begin preparation.
This courtroom hearing ended with one message loud and clear. The judge is officially out of patience. What started as another probation review quickly turned into a serious warning about violence, accountability, and the very real possibility of prison time. The court acknowledged the defendant's difficult past, drug struggles, and mental health issues, but at the same time made it crystal clear that excuses no longer outweigh responsibility. And honestly, that moment hits hard because you can hear the judge trying to balance compassion with public safety. Legally, this was a massive break for the defendant. Even after multiple violations, failed conditions, new assault charges, and aggressive behavior, the judge still chose treatment over prison.
So the
That's
third
not
degree
something courts hand
felony
out forever.
conviction,
Programs like
if
SAF
true,
are designed to
would
rehabilitate
enhance
offenders
your
before the
punishment in
system
this case
completely
if
gives
you
up
were
on
found
them.
guilty
But the judge also
to
warned
the
that one more
second degree
violation
range
could
of punishment,
instantly flip
which
this
is
case from
between 2
probation
years
to
and up
years
to
behind
20
bars.
years. Do you
And
understand
did
that?
you notice the shift in tone?
Okay, and it
Once
looks
the
like we
conversation moved
previously
from drug use to
did
violence,
a plea bargain
the
rejection,
entire hearing
and
changed.
at that time,
That's usually the
third
line
degree
courts take
felony
most
was
seriously,
checked off
because now the
instead
concern
of the
becomes
second
danger
degree
to other people,
admonishment. But I do
not
want
just
to make sure you
self-destruction.
understand
So
today
now the
that if
real
you go to
question is,
trial and
will
if
this
that
defendant
conviction for the
finally
third degree
use this
felony, the
opportunity
state
to
jails
turn
don't
his life
enhance
around?
you, but the third
Or are we
degree
watching
would
the
to a second
final
degree
warning
felony.
before a prison sentence becomes
Range of
inevitable?
punishment. It looks like that
Drop your thoughts in
rejection
the
was
comments
for a
below.
4-year term in
Do you think the
prison. Is
judge made
that
the
still
right decision by
the
giving
offer?
one last
That was the
chance?
offer as
Or
of,
should
this
prison have been the
morning.
outcome?
Okay,